Good afternoon. Welcome to Washington Legal Foundation, our web seminar series. My name is Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 41st year of continuous advocacy and education for free enterprise values and the rule of law. The web seminar series is one of our two communications programs. We also do media briefings as well. The bulk of what we do and our sort of beginning mandate is to be a litigation advocate on behalf of concepts of free enterprise in federal and state courts as amicus, and also some original litigation and filing of comments in regulatory agencies. In addition to that, our Legal Studies Division acts as our in-house think tank. We are proud to have a wide range of experts write publications for us. We also have a very active blog that Michelle writes for quite often with his colleague and advisory board member of ours, Greg Brower. When asked after the 2006 election his thoughts on reacquiring the chairmanship of the vaunted House of Representatives Committee on Energy and Commerce, the late John Dingell was quoted as saying, "As the Lord High Executioner said in the Mikado, I have a little list." We're not sure if Committee on Oversight and Reform Chairman Cummings or any of his fellow committee chairs uttered anything similarly ominous after the 2018 election, but for regulated businesses and others under Congress's thumb, nothing really needed to be said. They knew that even though House committee investigations and oversight of the White House and executive branch agencies would get all the attention, those committees would identify some quote-unquote legislative purpose to turn on the magnifying glass on them. And no doubt some Senate committees, not wanting to be one-upped by the so-called lower chamber, would be turning up the heat as well. As most of you know, congressional investigations are unlike any civil or criminal investigation, prosecution, or private litigation that businesses and individuals and their lawyers must manage. Every committee of each House of Congress has its own rules, guards its turf jealously, and is overseen by a chair and populated by members that each have his or her own political and ideological agendas. Washington Legal Foundation is honored to have a former House committee chairman, along with two former senior counsels from prominent House and Senate committees, with us today to discuss the rights and wrongs of strategically responding when Congress comes calling. We'd be happy to take your questions. For those of you who are joining us online, there's a question and answer template next to the screen, and you're welcome to type those questions in. I'll be asking those if you send those in. I'm going to introduce the speakers in the order in which they will do their presentations, and then we'll get started. The Honorable Tom Davis is a partner with Holland & Knight here in Washington, D.C. For 14 years, Mr. Davis represented the 11th Congressional District of Virginia in the U.S. House of Representatives. He chaired the Committee on Oversight and Government Reform from 2003 to 2007 and served as the elected chairman of the National Republican Congressional Committee from 1999 to 2002. Prior to his election, Mr. Davis served 14 years as general counsel for a publicly held professional services firm in McLean, Virginia. William Michella is a shareholder with Brownstein Hyatt Farber Schreck LLP here in Washington as well. In the U.S. House of Representatives, Mr. Michella was Chief Legislative Counsel and Parliamentarian to the House Judiciary Committee, General Counsel of the House Rules Committee, and Counsel to the House Government Reform Committee. At the U.S. Department of Justice, he served as Principal Associate Deputy Attorney General, and in 2003, the U.S. Senate confirmed Mr. Michella as Assistant Attorney General of the Office of Legislative Affairs. Also joining us, hopefully, eventually, is Stephen Cash, who's counsel to Dave Pitney. I will give a larger presentation of his credentials once he has arrived. Tom, if you can get us started.
Well, thank you. Let me start with where you started, and that is that every chairman has their own agenda. I wish there was you could come up with a cookbook of what to expect in Congress in terms of how they're going to do investigations, but what you find is every committee chairman has their own agendas. When a new committee chairman comes in, particularly right now where you have switched a party leadership in the House from the Republicans to Democrats, a lot of the outgoing staff are gone, new people are brought in, depending on what the agenda is for that incoming chairman. Is it a legislative agenda? Is it an oversight agenda? What do they have in mind? And I'd add that as I have observed Congress over the last 20 years, what you find is when the president's party is in control, they tend to under-investigate the executive branch. When the opposite party is in control, they tend to over-investigate. And I think we're going to see the same thing here. That was really true. I saw this in 2007 when the House flipped, and Henry Waxman, who succeeded as chairman of the House Government Reform and Oversight Committee changed the name to the House Oversight and Government Reform, emphasizing oversight. And as was stated in the introduction, he had a long list of pent-up demands that the Republicans wouldn't investigate that he wanted to investigate. As chairman, we have, and particularly on the investigative committees, you have a wide range of what you can do. The House Oversight Committee can issue a subpoena and can investigate anything at all. There are no limitations. I did steroids in baseball. People say, how was, where did you have the jurisdiction for that? We, of course, did the investigation of Hurricane Katrina. We wrote the investigative reports on contracting in Iraq, and about 100 other investigations during our time. Succeeding chairmen have taken different attacks. In many committees, they have defined jurisdictions, which defines what they can do, and Will can talk a little bit about that. Judiciary Committee has a defined lane of jurisdiction of which they can hold a hearing on anything within those lanes. The Oversight Committee can do it on any lane and investigate what is technically jurisdiction of any other committee because they have oversight over everything. This committee was created in the 1950s. It was put together because we found out that the investigative, or that the committees of jurisdiction got very close to the agencies that they were supposed to oversee. So the Armed Services Committee got very close to the Defense Department and was there more likely to cover up wrongdoings in the Defense Department than expose them. Same with the Agriculture Committee and the Department of Agriculture, and so on and so on. So they put together what was then called the Government Operations Committee that could look across government and not have any vested interests or long-standing ties to any of the particular government agencies and could do oversight over anything. And over time, that committee was given tremendous power, subpoena power with the chairman, where they could, in fact, do anything they wanted to. There's a tighter rein on them today, I think, from leadership than when I was there. Nobody, never from leadership did they come to me and say, you have to do this or you can't do this, even though there were entreaties sometimes from outside interest groups that try to hold me back. But today what I found is chairmen are reluctant really to buck their leadership on any item of controversy. But for minor items, they still have a very, very wide latitude. So let's talk about committees of jurisdiction and start with the fact that how do you create that agenda as a committee chairman for what you're going to hold hearings on and what you're going to investigate. First of all, in committees of jurisdiction, every year they're going to take a look at acts that are under their jurisdiction and call up agency heads to testify over what's going on with their agency, kind of give an updated report and ask questions. On the Oversight Committee, it's a little bit different. They certainly have oversight over some of the, certainly over the White House, Office of Management and Budget, some of these areas. But they will put together a list very early, and I can tell you, as Congress flips, as you have a Democratic Congress and a Republican administration, Democrats are looking at a pent-up demand to investigate issues in the Trump administration. They felt the Republicans should have investigated that they hadn't done, and they are proceeding on that, as well as the Judiciary Committee right now, who's just issued over 80 subpoenas to people in and out of the executive branch. Oversight Committee doesn't have jurisdiction over most of these issues to write any laws as a result of these hearings, but they have the ability to hold a flashlight onto these issues and to magnify their importance. What will happen to your clients? The first thing they will generally get is a written request from the committee for documents. They'll say, we'd like to request certain documents. This is generally the first step, and it is only a request. You're not legally bound to comply, but our advice is if you don't comply, more often than not, they're going to follow up with a subpoena, and all of a sudden you get moved to the top of the pile. So when you get a request for documents, my experience has been they're usually far-ranging documents. It's kind of asking for the kitchen sink. You sit and look at it, try to figure out where they're going, and then you want to contact the committee, go up and see the committee and say, what do you really want? What documents do you really, you want to narrow that scope, because just responding sometimes to these requests can go run into hundreds of thousands of dollars. So you want to go up and make the argument that what do you really need, this is an expensive process, et cetera, and try to narrow that. Often these are bipartisan requests. Sometimes they're not. They're partisan requests, at which point you can go to the minority in the committee and have that conversation too. They don't have the votes necessarily to do anything, but they can also help limit the scope of what the documentation that the majority has asked for. So you want to narrow that scope and try, if you can, to reach an agreement over what documents they want. That may or may not lead to a public hearing. They may take these documents. They often, I'd say over half of the requests for documentation, there's never a public hearing on this. You want to try to be as cooperative as you can on these issues and be as conversant and get as much intelligence as you can at that point. There are several things you want to protect against. First of all, is brand damage. If you're called up before a committee, your brand can suffer. Committee chairmen cannot assure what their members will do. Often they're saying, well, we can keep this information private, we can keep it confidential. They can't always assure that, because other members see this and are prone to go their own way. We saw this with Cory Booker in the Supreme Court hearings, but I had a committee with a very eclectic group of members on the right and the left that were uncontrollable by either Mr. Waxman or myself, and so we were very careful how we handled these documents and wouldn't share them with other members unless we were pretty sure they were needed and everybody had an agreement over what was going to happen to them. So these documents may or may not result in a hearing. Generally, you want to keep your clients away from the hearing process because the public hearing process can become unpredictable. Again, the chairman and the majority may have their talking points. They may have an agenda, but there are members that go off sideways on these hearings that they cannot always control. Things get written up in the press, and it is a more unpredictable nature. You certainly, if you're called before a hearing, you want to go up and talk to not just the majority-minority staff, but to individual members if you can, particularly if you have an office in a member's district, and walk them through what your fears are about the hearing, what are their concerns, try to understand ahead of time what you're going to get asked so you can be prepared to answer them. Nothing particularly wrong with that. And I would request those are the kinds of things that you do. And if the hearing is called, it is important you understand what they're going to ask so that you can be fully compliant as they ask these questions and not be surprised and not have to come back or get shredded in a public outing, in a public hearing. How do hearings occur? Again, you have the committee chairmen have their own agendas at the beginning that they'll put forward at the beginning of the year, but that's subject to change. An article in the newspaper, sometimes Congress can be very reactive. If they can get a lot of newspapers into the room, a lot of TV cameras in the room over a hot topic, you can get called on a dime, sometimes not have much time to respond. The most dangerous place in Washington is getting between a committee chairman and a TV camera, and we see time and time again where they are Congress and committees in particular are very reactive to what the press is writing about that day. A third area that's not mentioned about is sometimes your competitors will find something out and you will leak it to a friend on the committee and try to pull an investigation. We had a number of investigations where there were trials going on, and the trial attorneys, the trial lawyers would come up, get a hearing on a certain subject, and feed the questions to the majority at that point where they could ask these and then be used in court later on, or be made part of the public hearing that could be entered into court documents. You need to be careful and understand why are you there, what do they want, and the like. And so Congress is often reactionary to what's going on in the public and will listen to somebody that's trying to plant a bad seed on another company by going through a committee member and starting an investigation in that way as well. During my experience, some of our most potent investigations came when somebody came to us with information about another company or individual, and we went after them, and people end up going to jail over these. So I think when you get a request, again, just to summarize, you want to find out what the staff wants, narrow the scope of that request. It's going to depend, and we can get into the weeds on this and how you might react in a certain situation. But you want to narrow that scope, try to avoid the subpoena, because once that subpoena comes in, a lot of other issues come into play. And Will and I can talk about what you do if you're subpoenaed, how you have to comply, my advice would be dependent on the situation over how you comply, what you do at that point. So I think that gives kind of a broad overview from a committee chairman's perspective. And Will, I'll pass it on to you.
Thank you, Tom. Bill?
Well, great. Thank you very much for the introduction. It's great to be here with former Chairman Tom Davis, who really did a remarkable job as chairman of the Oversight Committee. I think one of the hallmarks of his tenure as chairman was to live up to some of the great traditions of that committee, in which they did a lot of programmatic oversight that led then to reforms in other parts of the government. While we're waiting for Steve, I've amended my presentation very quickly on the spot. I'll cover a couple of the things that I think he was going to cover, just to get to some basic first principles. We could spend an hour on each of these topics, but just to lay out what congressional oversight is, what its constitutional basis, etc. So there's a general understanding of these things for our discussion. Then I think I'll transition a little bit into some tips and hints for practitioners. So why does Congress even have this oversight authority? It really stems from the parliamentary practice in England, and the Supreme Court recognized very early on that Congress needs information to educate itself about legislating. The Supreme Court, in a number of cases, including some from the Teapot Dome scandal, actually kind of lay out the parameters. And when Congressman Davis says that the Oversight Committee has jurisdiction over everything, that's almost true, but not quite. There are some things that are off limits for Congress. So the big picture is that Congress's oversight authority is coextensive with its legislative authority. So that's pretty broad. Given today's jurisprudence over the Commerce Clause, which is extremely expansive, almost nothing is out of Congress's reach. But Congress does have to have a valid legislative purpose. It doesn't mean that it's going to pass legislation. It doesn't mean that it's got a bill in the hopper ready to go. But there at least has to have some articulable hook to legislation. There's Supreme Court has also said that Congress's power isn't for exposure's sake. So the more the congressional investigation looks like a prosecution, the more it looks like it's going after an individual, the Congress may be testing the limits of its authority. So a key part then of Congress's constitutional authority to get information is how does it actually get it? And Chairman Davis mentioned the subpoena authority. After the document request is sent out, those of us who do this on a daily basis sometimes call these dinglegrams after Chairman John Dingell, who was very famous for sending 10-page letters with 50 interrogatories, and each one with 10 to 15 subparts. If this committee doesn't feel satisfied, it can issue a subpoena. Now, it wasn't always, in today's practice, most committee chairmen can issue and authorize subpoenas. That wasn't always the case, at least in the nearly 30 years that I've been in Washington. When I started in this town, only the Oversight Committee in the House and PSI, the Permanent Subcommittee on Investigations in the Senate, had that unilateral subpoena power for the chairman. Today, just about every committee, at least in the House, has that. And what can the Congress subpoena? Of course, documents and testimony. And that testimony can come in two forms. It can be public testimony in a hearing, and it can be for depositions. It used to be the case when I was a relatively young lawyer on the Oversight Committee, there was no staff deposition authority. During the campaign finance investigation during the Clinton administration, was a grant of staff deposition authority. I actually like, there's some real benefits to staff deposition authority. As Chairman Davis noted, anything can happen at a public hearing. Committees operate under something called the 5-minute rule. You've all probably seen committee members asking questions under the 5-minute rule. It is not a device designed at adducing the truth. And the witness often will be cut off, can't get their entire story across. And so while some view staff depositions as scary and may want to be in public for other reasons, staff deposition authority may actually get to the truth faster, and for your client potentially, cut off the public testimony. So if you've received a subpoena, what are some of your defenses? Well, as I've already mentioned, the constitutional basis for congressional oversight has at least got to be somehow tethered to a legislative purpose, and so you would ask yourself whether or not Congress has a legislative purpose. Again, this is a tough one to argue in court. Courts are going to be very deferential to the Congress. But the quintessential example of this that I like to bring up is if Congress decided to do oversight over the president's exercise of his pardon authority. The pardon authority is consigned clearly to the executive branch. It's a power not shared by the Congress. It's a power only the President of the United States has. And attempting to exercise oversight over the pardon authority, I think, can be challenged by the executive because Congress cannot legislate in this area. Congress could not set, for example, criteria for the president to consider when considering and issuing a pardon. But again, it's got to be tethered to some valid legislative purpose. Committee jurisdiction. There are committees, and I have made this objection on behalf of clients. Committees have to have jurisdiction over the matter in which they're investigating. Of course, the Oversight Committee has broad oversight jurisdiction. Their oversight jurisdiction, with a couple of exceptions, and I'll defer to Chairman Davis, particularly in the Intel area. But other than that, that committee can investigate, as Chairman Davis said, just about anything. But other committees are limited to their jurisdiction, which is laid out in Rule 10 of the Rules of House of Representatives. The Senate has a similar rule with regard to committee jurisdiction. So if committee chairman is looking at a matter outside of their jurisdiction, you could object to that. Potential due process concerns. Subpoenas have been challenged because the recipient of the subpoena did not know the scope of the oversight inquiry. So the subject or target of the inquiry needs to at least have an articulable understanding of what the oversight is about. Of course, constitutional privileges obtain in the congressional context. So the Fifth Amendment, of course, is available to witnesses, as is the First Amendment. Now, I have, this is not one that you hear very often, but I defended an advocacy organization, and a committee had issued a subpoena to this advocacy organization and wanted to know about kind of some of the inner workings. This advocacy organization was created solely to exercise its First Amendment rights to petition the government and to associate with like-minded groups. And so there are cases like NAACP versus Alabama, in which the government attempted to obtain membership lists. There are some limits that you can bring to bear if the congressional oversight ventures into this area. And of course, an assertion in this area really gets back to my very first point. There's got to be a valid legislative function, and of course, the First Amendment says Congress shall make no law, and if Congress cannot make a law in that area, you have a potential defense if the Congress is trying to inquire into protected First Amendment speech. Now, if you take the Fifth Congress has, there's a statute that permits Congress to immunize a witness. And the Congress can do this both for documents or for testimony. So for example, if a witness refuses to hand over documents, I've been involved when I was on the Hill, immunizing the act of production, and so that we could at least, Congress could get documents. That's not something that you see every day on Capitol Hill, but in rare occasions it is used. There's built into the statute a consultation process with the Justice Department, because oftentimes if you're immunizing someone, there's a parallel investigation somewhere else in the government. Failure to comply with a congressional subpoena subjects one to contempt of Congress. We've seen this particularly in the governmental context. Now, Attorney General Holder, for example, in the Fast and Furious Oversight was held in contempt, but Attorney General Holder and other government actors have a defense not available to private parties, which is if the President asserts executive privilege, that will protect that government official, at least for a short period of time, while the issue is litigated. You can one can challenge the committee on any of these bases. The problem for private parties in this context is that Congress has an authority that the executive branch doesn't. So if you get a subpoena, a grand jury subpoena for documents, for example, you could move to quash that subpoena and litigate that issue right then and there. That issue, that avenue is not available to private parties in the congressional oversight context. Why? Because of the speech or debate clause. The speech or debate clause says that a member of Congress will not be questioned when they're fulfilling their congressional responsibility. And so in all of these matters, even when an executive branch official is held in contempt, you don't see somebody going to court, litigating it, and then having the committee vote the contempt. The process runs its course, the individual is held in contempt, and then the matter might be litigated. So there is a real risk on behalf of a private party who decides not to comply with a subpoena. You could face criminal jeopardy under the criminal contempt statute without the ability to kind of resolve that before the contempt citation is issued. Chairman Davis mentioned one of the principal risks to private parties, and that's the reputation risk. If you are in the C-suite and you've just heard from your general counsel that you've received a subpoena, your general counsel probably knows that because they either received the subpoena or a reporter is calling the press office asking about the subpoena. And of course, you want to engage any number of strategies to mitigate the risk. And in this day and age, the risk really can multiply very quickly. One of the most problematic, one of the biggest challenges for anybody in this situation are the parallel and collateral investigations that are likely to ensue. If a matter is in, we're reading about Boeing is in the newspaper these days. There are IG investigations, Justice Department investigations. The FAA is obviously looking at it. It sounds like the Office of the Secretary of Transportation is looking at it. I don't know if any states are looking at it, but state investigations are oftentimes running parallel to a federal regulatory body. There may even be a foreign regulatory body looking at these matters. And so understanding the risks associated with all of those investigations and balancing those with the high profile and oftentimes very public congressional investigation is of paramount importance. And I can't overemphasize that preparation is of key importance. You wouldn't go into a grand jury without being prepared. You wouldn't walk into a proffer session at the Justice Department without being prepared. You shouldn't take what Congress does for granted, in part because the Congress can make criminal referrals for making false statements to congressional investigators, and those are real risks. A member of Congress or their staff might say, just come on up, we'd like to talk to you. We just want to get the story straight. Oh, I've seen this before. They get take an interview, maybe even do a transcribed interview, and then they say, you know what, we want to learn more. Why don't you give us all the documents? And for those who are watching this webinar who have dealt with private clients, their memories are never perfect. We know this. There may have been emails, texts, other communications from years ago that they just don't remember in good faith. And then they turn up later, and then the congressional staff is wondering, and members of Congress are wondering, what the heck is going on? Why didn't you tell me this? Why did you leave this out? What are you covering up? Chairman Davis mentioned, we were talking about this before we started, the real business-sensitive material that Congress may request. Congress is doing some oversight right now over drug pricing. That oversight may include requests to companies about very sensitive internal pricing information. Well, you certainly don't want those things made public. What can you do? And again, we are seeing more and more that members of Congress are taking it upon themselves to disclose information. During the Kavanaugh hearing, of course, Senator Booker took it upon himself to release some information, and he made a point of saying that he could have been sanctioned by the United States Senate for his conduct. Other members of Congress have released information. It used to be that you could have an agreement with the chairman and ranking member over the confidentiality of documents. And in my experience, those things were abided by. Those agreements were abided by. They really were. Now, I really worry about that on behalf of clients. There isn't a rock-solid way to ensure that your clients' documents are going to remain confidential. Best case scenario, you convince the committee that your cooperation is contingent on them passing a committee resolution, which means they have to meet in open session, have a collegial session at the committee to deem any material produced by your client or in the course of this investigation is taken in an executive session. Does that protect the information from disclosure? No. A member of Congress who gets their hands on it or their staffs could release it, but it potentially subjects them to sanctions by the House or Senate Ethics Committee. It would also require a vote of the committee to release those documents. So it's not a guarantee, but it certainly is a relatively high hurdle. I was asked to talk a little bit about the role of the minority. The role of the minority, particularly in the House, is usually one of defense, particularly when the oversight is more political. But there is some power and authority in the rules of the House the minority can exercise. One is that the minority is guaranteed a day of hearings. I was talking to somebody the other day on the Hill. Apparently a memo that I wrote when I was General Counsel of the Rules Committee is still floating around, in which I took the unpopular position at the time that a day of hearings actually means a day. The chairman of the committee can still schedule that hearing on a Friday, make it as inconvenient as possible for members, but a day is a day, which basically means if a hearing as a general matter starts at 10 a.m., which they usually do, or 9:30, it goes to its logical conclusion, around 6 or so hours later, to about 4 o'clock, or to when the hearing ends. And interestingly enough, while hearings normally come to a logical conclusion and you see a gavel go down, the committee chairman can't unilaterally adjourn the hearing. So as long as there are more members of Congress who want the hearing to continue to be in their chairs, the chairman just can't shut the committee down. A motion to adjourn won't be sustained circumstance. Members of the minority can raise pertinency challenges. I believe it's clause 2K8 of House Rule 11, which makes the committee the arbiter of pertinency, and so evidence could be excluded if the committee deems that that information is not pertinent. If there's another rule that's rarely used, but clause 2K5 of House Rule 11 says that any person who alleges that testimony adduced at a committee hearing would tend to defame, degrade, or incriminate somebody, a motion lies to move that portion of the hearing into closed session. So there are a small handful of things that the minority can do, and of course, any high-profile hearing, you're going to brief as many friendly members and staff of your issue so that you can get your story out during your 5 minutes. So that's a lot of information in a very short amount of time. As I said, we could probably spend an hour on just the subpoena power, just the constitutional authority of Congress, just the various due process challenges that might lie, but I'm looking forward to questions.
Yeah. Well, let me just, Will's hit a couple of things I just want to follow up on. First of all, you can, in the Terry Schiavo case, we actually subpoena the feeding tubes. So you do have the authority to go just beyond looking at people and documents. We'll mention the 5-minute rule. It is critical you understand the 5-minute rule, because if you use that to your advantage, if you happen to be on the menu that day for the committee, knowing that the questions of a questioner end after 5 minutes, help you to take a glass of water, take your time in answering, and then you move over to the minority side to answer questions. Many times that will break up what could otherwise be a very adverse interrogation. How do you prepare? I think the one thing I would say is you want to be familiar with all the documents the committee has to the extent that you have it. You know what you produced. If you send your client up there and they're not aware of all of the documents the committee has, or that at least that are available to you, they could get asked these questions, and not being able to answer or explain them can put them in a very embarrassing situation. You got to know who your allies are. The minority does play a role in that. Generally, the minority just picks up a paycheck and makes up the quorum. But in an investigative situation, the minority, after 5 minutes, it rotates to the other side, and the minority can then ask a question and change the subject. And if you've communicated with them and are feeding them the questions, they can sometimes shift that emphasis back. They can correct any misunderstandings that could have been perceived from your client's testimony. Also, you can, in the opening statements, members get opening statements. Sometimes in a hearing per se, it's the chairman, the ranking member. If you can have your client with a defense in the opening statement or setting the ground rules, I think that is helpful. And other members are allowed to submit statements for the record. I think to the extent you can have those friendly members put something in the record on your behalf, I think it can also be very, very helpful downstream. You need to, again, try to limit your time. If your client is before the committee, you can sometimes get an understanding. You got 4 hours. This is the time period. Often in these committees, they're supposed to start at 10, and by the time the members are through making their opening comments, it's 11 o'clock. Then you have a vote coming in, and your client can be stuck there all day. Committees are often broken up by votes over on the House floor where they're adjourned for periods of time. In fact, you need to use those times accordingly to kind of get up to snuff on where the committee's going, making sure your client is able to answer or correct any misgivings that might have come across from their testimony. But if you can get an understanding that my client is only going to be available for 4 hours during this time, try to do that. That can help you as well. And you need to have a media strategy if it looks like this could be a real hostile hearing. Oftentimes what we would find is the majority or minority, one of the sides would release their statement the day before the hearing. They wouldn't wait, and the press was eager to pick this up. And there's stories on the front page of the paper, and the hearing's like an afterthought. And our client is, or your client could be stuck there not having had their say because the newspaper's already run the story with the group that leaked it. You need to be aware of that and have a media strategy going into these items. So I would just add that in terms of some of the experience we've gleaned through time. Take questions.
Mr. Cash had emailed me and said that he had a very unexpected, unfortunate conflict arise this morning, and he wanted to send his regards to both the speakers and his apologies for not joining us today. If you have questions, again, joining us online, there is a Q&A template that you can type your questions in. They come to me, and I will ask them to the speakers. I'll get it started, though, instead. So some hearings are held in support of specific legislation, while others are to spotlight an issue or perceived abuses. Is a business or a governmental entity's preparation different based on the motivation of the committee?
Absolutely. Let me just start. Sometimes we'll take clients and want to get them before a committee if it's on subject matter expertise. They get to go out there, they get to testify before this committee, they can cite this then in their resume that we are congressional experts and we've been called to testify in this subject. Now, I don't always, you need to understand exactly what you're getting into, but this morning we had a client come up on a small business issue before the committee, got them up to highlight this. So I think it can be used on offense and on defense as well. So many times if it's a legislative piece, you're representing clients or your client is up there showing their expertise, that's important. Again, I think preparation is important. They need to understand the questions that could come at them. They need to understand that there may be people in the committee that view it a little bit differently, and they need to be prepared to answer those kind of questions. But that can be advantageous to a business, to be a leader in their industry, to be called upon Congress to testify as an expert. If, on the other hand, you're a part of an investigation, and we'll mention collateral damage, many times you can take a look at the Boeing situation. I'm sure there'll be hearings on this, but the collateral damage, if you wrote software, if you were another airline and didn't buy the additional software, a lot of times if you're not prepared and hit this head on, you could be thrown under the bus as well. So I think it's you need to understand, as I said in my opening comments, why is the committee, what are they asking for? Don't give them more than they ask for. Try to narrow that and try to understand where they're going, and that's your roadmap to try to either limit the damage or in some cases, enhance your reputation. Well, you want to
Additional thoughts, Will?
The only thing I would add in the investigative context, just about everything is negotiable. Oftentimes, staff or their members have a big picture idea about what they want, and they ask for everything. They really don't want 2 truckloads of documents backing up to the Oversight Committee. And you can, on behalf of your clients, negotiate down to those documents that the committee really is interested in. Now, sometimes they'll say, no, I want it all, and produce, all the garbage, and they'll have to, wade through it. But oftentimes you can negotiate that, and I think a lot of staff appreciate, and members will appreciate, that you've helped, narrow the request to the key pertinent documents. You're not wasting their time. You can build trust in that way, but you can negotiate over kind of testimony documents and the like. And of course, this goes to Chairman Davis's point, which is understanding what they're really after. And if you can understand that, then you can help them navigate, to what's important.
Let's say in your documents you have a smoking gun, and you can't negotiate your way out of it. You don't have to comply with the request for production. And if you don't comply with the subpoena, the committee on itself can't just issue contempt. They've got to take it to the House floor. They've got to get a vote in the House floor. And I have seen investigations fail because the committee didn't want to waste floor time and everything perfecting at the House floor level, depending on what the level of negotiation is. So there may be those rare cases where there's just something out there that if the government if Congress gets a hold of this thing, it's the end of the company, where you might want to hardball this. As a general rule, we favor cooperation because cooperation is more, you catch more flies with honey than with vinegar. But there are those cases where you have to understand how it works, that Congress needs an affirmative vote, and they got to serve it on the U.S. attorney, and the U.S. attorney's got to, and it's a long, drawn-out process. And I've seen situations where you run out the clock on the Congress, and they end up not getting it. But that's rare, but it is a strategy that in some situations may be applicable.
The one tiny asterisk to that is that the congressional contempt statute does have a provision in time of recess that permits the speaker to certify the contempt citation approved by a committee to the U.S. attorney, and that could avoid the House floor vote. So hasn't been, I don't think that's been done in my tenure in DC, but that's certainly part of the statute.
I think they did it on the Shibo issue.
On the Shibo issue.
The Shibo issue, it was over a weekend, they needed to work it very quickly, but it's done, that was where it was very quick, they were going to take away the feeding tubes, and they wanted to at least see if they could get legislation passed, but very rarely exercised. But you need to understand those procedures in terms of what your options are in situations like that.
So there's been a couple of instances since the House switched sides where at least one member has quoted from documents in litigation to people who are testifying at that particular time that basically counteract or contradict what the testimony, person who's giving testimony is given. How can you, as a counselor to companies, anticipate that and make sure that doesn't happen to your clients when they go up and they're in front of the microphone?
I'll start. I mean, first of all, you need, as I said, you need to know your documents. You have to go through this and thoroughly, and you need to turn it a page at a time. Trying to walk over, you may miss something and you get surprised at something like that. And look, I had, we had a couple members that we referred over for lying to our committee. Major League Baseball players, one pled guilty to a misdemeanor, the other, Roger Clemens, had to go through 2 trials to show they weren't. So, believe me, lying to a committee is serious business. Getting caught in those kind of issues can be a very expensive undertaking, and you need to understand going in where it is. Now, the committees will oftentimes give you, if you're challenged like that, give you a chance to explain it. But if you have to make it up right there in the middle of the committee hearing, it's probably not going to be as successful as if you could have anticipated this ahead of time. So the key is to have that record in front of you and make sure you are prepared as you walk in terms of what are the most adverse questions they could ask. Will.
Understand all the various parallel investigations that are out there. You know, the committee, you might have a regulatory matter that was closed at the SEC, let's say, but civil security litigation is ongoing, and the committee has already received information from the SEC and maybe even the plaintiff's lawyers in the securities case. You got to know all of that because the committee very well may have those documents.
There's been some instances of this in the past that I think I recall correctly, where plaintiffs' lawyers will come to the committee with documents that are under a protective order that they have through discovery, and wanting to share those documents with the House, basically laundering those documents through the House or the Senate committees. How frequently does that happen, and how would you deal with that as either a staffer or a member or a chairman?
Well, from a staff perspective, or from even Congress's perspective, the protective order that you described is unlikely to apply to Congress. If it's information that's relevant to their investigation, they'll take information from whatever source it is, whether it's a plaintiff attorney, a whistleblower, whatever source, they will take it and they will use it to their advantage. You could attempt to run to court to get an order, not to disclose something like that. Unlikely, however, to apply to Congress. These things don't happen, in my experience, too often. I'm not a historian of the tobacco litigation, for example, but I do know that plaintiffs' attorneys work very closely with the Congress during that episode, and this is an area where Congress, gets information.
Let me add, let's talk about the Fifth Amendment for a minute. There are some instances, and we had a number of witnesses take the Fifth Amendment during the campaign scandals in the 1990s where they came up. We had over 100 witnesses either fled the country or took the Fifth Amendment. The campaign scandals in the late 1990s. But one of the things we were able to utilize is the use of immunity. Congress can generally get use immunity without a huge problem. Transactional immunity, much more difficult. But use immunity means what you say before that committee. Now, Justice Department, if they have other ongoing investigations, may fight you on that and give you some pause to do that. But you need to be aware of the fact that the client still has the right to take the Fifth Amendment on these issues. And if you can get some level of immunity and it's in your client's interest, you can negotiate that. We were able to utilize this on occasion.
So drawing on your experience, Tom, as a former general counsel, what kind of role can a general counsel's office play in investigations dealing with testimony, those sort of things. before
So I think
Congress.
in any job, but particularly for general counsels, I was a general counsel to a couple companies, public, and the first thing is to know what you don't know. Don't think you can just handle this. This is the risk involved here is high enough that it's worth spending a little money up front to make sure that it just doesn't go south on you. So get good counsel up front. And understand what are the ramifications of this instead of just trying to do this on the cheap and say, oh, we can handle this, or I'm going to go up and talk to the committee by itself. There are a lot of traps that can be laid in these requests for documents and the like. Know your limitations. General counsels aren't supposed to be fluent in this kind of thing. This is generally going to be outside the expertise of anybody within that corporation. Get help up front, and it'll save you down the road a lot. If you overpay up front, you overpay, but at the end of the day, it's worth it rather than having an investigation go south on you, because once you get into this thing and start doing it yourself and you've gone the wrong direction, it's just hard to recover.
And I'd say, just to add to that, be a good quarterback. This is a multidisciplinary type of problem. You need legislative affairs assistance, you may need public relations assistance, you may be relying on criminal law counsel, counsel with expertise in governmental investigations, including congressional investigations. Understand that you need to bring all of that expertise to bear. I've seen responses to congressional oversight where it was just housed in the GC's office and it was a mistake. They, for whatever reason, decided this is a GC's matter. We're not going to involve our very experienced congressional affairs team. And if you're a Fortune 50 company, you've got congressional affairs professionals. You've probably got people who have, although they might not specialize in congressional oversight, have a political sense about these things, because ultimately, while I went through some rules, and there is some law relating to congressional investigations, this is a political process with political actors in a political forum. And understanding that dynamic is much different than making your case in court will serve the GC much better than just trying to keep this as a kind of a narrow legal issue.
Yeah, this is not a legal proceeding in the traditional sense. It's very political. You have to ask, am I worried about the criminal elements of this? Am I worried about reputational damage? Am I worried about competitively what this does in terms of information that can be gleaned on the, and understand what the damages can be up front, but get help. This is one area that's outside the scope, I think, of most lawyers' expertise and most general counsels. Don't be afraid to get help.
About situations like we're seeing with drug pricing, for instance, where it's an industry-wide investigation and there's a lot of different letters going out and then there's hearings. Have you seen or dealt with collaboration among industry leaders? Is there concerns with competition questions or antitrust questions when you're trying to deal with an industry-wide investigation? Or is it usually like one company deals with it on
I've been through all of them as in the minority, because Chairman Waxman basically wanted to look at all the drug pricing and get it. And our counsel to a lot of these companies don't give it to them. I don't think you're going to have to give it to them. This is confidential. And many of them folded and just gave him up. And those were the committees, those were the companies that got called before the committee. Look, when there's a broad brush like that, the first thing you want to use, client, is you don't want to be the people up there having to testify. Make it the other guy. And there is, I think, something about, in this case, pharma groups banding together, having a strategy, but you also have your individual strategy for your company. Because being called up there over some drug that somebody thinks is overpriced merits a headline somewhere that can damage the brand of the firm.
I think it's a really good question. So the Noor-Pennington doctrine does not apply in the congressional oversight context. At least I don't think antitrust authorities are going to argue that. That's really about petitioning the government for redress of grievances, if you will, kind of traditional lobbying that Noor-Pennington applies. I've seen some situations where common interest agreements or JDAs are entered into loosely. It really doesn't work as well in the congressional context, but you can coordinate a little bit with some of your similarly situated targets out there, if you will. When are you replying? How much you replying? You might want to know what one target of the investigation is going to give a very fulsome response, but your general counsel is leaning towards a nothing. You want to know that ahead of time. And so some of that can occur. You just have to be careful. You certainly aren't going to be able to share the pricing information or marketing information or things like that as a part of those discussions.
We had, this goes back a ways, an issue where our client was not going to be able to avoid getting called up before a Senate committee, and we were able to negotiate that our competitor got called up as well.
Can you give us a couple of do's and don'ts in terms of negotiating with staff or with members on the scope of an investigation or a scope of a hearing?
Well, I think when you get a hearing request, they ask you to respond, and so they're basically asking you to respond. They expect you to call, either produce the documents or come up there, and they're likely to take the meeting. I've run into instances where they won't take the meeting, where they're going to go after you, and they don't want to have to look you in the eye ahead of time, and once they have those documents in. But I think the smart thing is to go around, figure who your friends are in the committee. Do you have an office in somebody's district? Do you know that member? Do you have a previous relationship? You go around and you tell your story, and you'd like to know, what is the order of the hearing, who's going to be called first, the first panel, the second panel, the third panel. A lot of that will tell you where the priority of the committee is and where their goal is. But I think you need to have you or your representative go around to as many members and staffs as you can to make sure that your story is being told accurately. If you can have friendly members, as I said, insert things into their opening remarks, make sure in the question and answer period if something goes south, you have a way to get questions to rehabilitate your witness up there. I think all of that's very important. This is member to member at the end of the day. The members are asking the questions. So having that relationship with their staff, or in many cases the member wanting to help you, is just critical at that hearing.
I agree with all of that. I think for me, the biggest don't is to try to pull a fast one or play games with the committee staff. You need to build a rapport and build a rapport very quickly. Oftentimes they're very happy to have an experienced lawyer dealing with them, somebody who understands document production, somebody that understands the committee, somebody that will ultimately understand what they're after. But they also have pretty sensitive BS meters. And if they tell the chairman that you've been playing games, the chairman can use his or her microphone to pummel your company or your GC or whoever it is. And so those are significant reputational risks. You wouldn't play games with the judge. Don't play games with the committee. If you're facing a delay in production for whatever reason, explain that. They'll understand that. They put deadlines in these letters, but the deadlines are negotiable. And if initial search came up with 100,000 documents, you got to review them for privilege. Well, then you can work through that, and you can talk. You can get very granular with them. Sometimes the committee won't. I've asked them. I said, "What are the search terms you'd like?" So that they're not, or at least have agreed upon search terms. So that you're not accused of, repressing something, and all that can be negotiated up front. But don't try to play a fast one. Play games with the committee. They will figure it out, and your client, and in this case a company, may be on the wrong side of the public relations battle. As Chairman Davis said, ultimately this is a political process, and if this is ultimately getting to a contempt vote, if you're arguing to those 20 or 30 members why they shouldn't support it, if they've been told that you played fast and loose with the committee, they're not going to be predisposed to help you.
I always say the pain may be mandatory, but the suffering's optional. and so it plays to be straight for as long as you can. And sometimes the committee will be the one jacking you around, and but counsel, I think, has their antenna up, can generally tell where that's going.
So what challenges and opportunities does the whole concept of overlapping and concurrent jurisdiction provide? Like the House Oversight and Reform Committee in the House can hear just about anything while the individual committees have their areas of.
If you're a hot topic, you could be called before 3 committees in the House and 2 in the Senate. You could have an ongoing regulatory investigation. You could have a criminal investigation on the side. I mean, what I do in a situation like that is you go to the leadership and say, look, we're happy to do this, but we can't do this 10 times. You know, give us a committee that we can deal with. If they want to do a joint hearing, let's get this thing. Look, committee chairmen and members like these committees to run smoothly. They don't like to have big clusters where people are yelling at each other back and forth. If you can get an understanding, as I said up front, into if you got to take the hit, you take the hit. But don't make this a one day. Don't make this a soap opera where it's going back and forth. So I think it all depends on the situations, but there is no need to have to go before 3 or 4 committees just because you've been in the punching bag in the New York Times or the Washington Post and everybody wants to get a bite out of you.
I agree.
We'll finish up with a question for Will. Sometimes these investigations and hearings lead to referrals to Justice Department for criminal investigation. What did you learn from your time at DOJ and in the Legal Affairs Division that speaks to that?
Well, this again gets to preparation. I'm not sure that experience specifically taught me this, but you know, I have seen situations where people have decided to go to the Hill without knowing the full story. And you got to know the full story before you go. And you may be getting a lot of pressure from the Hill. We want you up here, we want you up here, we want you up here. Well, it behooves you to do everything you can to be expeditious, but not at the expense of understanding the complete story. Because if you go up with 3/4 of the story and leave out, you know, a piece, particularly if it's a critical piece, you know, that will absolutely come back to bite you. Even if it's not, you know, particularly important, they'll say, well, if you're hiding this, you know, why are you hiding that? So I'm not a big fan of rolling productions. I'm certainly not a fan of doing interviews during the course of your production. Never seems to me to be a good idea. So, you know, just understanding the full story before you go up there.
And I've seen witnesses come up there with attorneys that were just ill-prepared. It's almost, you see it in the courtrooms too, where you get people that are just over their head. If you have a client and they come to you to help them, but don't be afraid to get help. This is a specialized piece of the law. There is no place to